29 U.S. C. Section 701 et sec. Involves allegations that because of disability defendants denied the plaintiffs full and equal enjoyment of the public swimming facilities and treatment by the local government employees to which they were entitled pursuant to the Americans with Disabilities Act. First, under the ADA, a plaintiff is not required to prove that disability was the sole reason for a defendant's discriminatory conduct. Rather, a plaintiff need only show that discrimination was a motivating factor in the defendant's action. Second, because plaintiffs allege that they have been denied equal access to services in violation of the ADA, they should not be required to prove, in addition, that those services were educationally and medically rendered for the disabled homeschooling needs, exercise and enjoyment for their group. Rather, each plaintiff need only show that, because of his or her disability, defendants denied the plaintiff full and equal enjoyment of the swimming facilities as compared to non-disabled individuals. Argument I. Plaintiffs need only show that disability was a motivating factor in defendants' discriminatory conduct. Title 3 and 2 of the ADA provides, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation by any person who owns, leases to, or operates a place of public accommodation. 42 U.S. C. Section 12182 A emphasis added. The language of Title 3 nor Title 2 does not include the word solely. Rather, Title 3 and 2 prohibits discrimination that is simply on the basis of disability. As the Supreme Court has stated, it is a well-established principle of statutory construction that absent clear evidence of a contrary legislative intention, a statute should be interpreted according to its plain meaning. United States v. Apfelbaum, 445 U.S. 115. 121 1980. See also FDUC v. Meyerland Co. 960 F. 2D 512. 516 5th Sir. 1992 noting Supreme Court's instruction to adhere to the plain language of a statute. Moreover, 7 courts of appeals including the Fifth Circuit have held that the word solely should not be read into the ADA. Rather, these courts have held that a plaintiff need only show that disability was a motivating factor in the defendant's conduct. See Newberry v. East Texas State Univ. 161 F. 3D 276. 279 5th Sir. 1998 Newberry was required to show that his disability or perception or record thereof was a motivating factor in the decision to dismiss him. Citing Hypes v. First Commerce Corp. 134 F. 3D 721. 726 5th Sir. 1998. In fact, it is quite clear that Congress did not intend for the word solely to be read into the ADA. In drafting the ADA, Congress did not include the word solely in any of the ADA titles, unlike in its earlier legislation, the Rehabilitation Act, C. 29 U.S. C. Section 12112 A prohibiting entities receiving federal funding from discriminating solely by reason of disability emphasis added. The intentional exclusion of the word solely in the ADA demonstrates that Congress wanted to ensure that the ADA would cover instances of discrimination where disability was one factor, even if it was not the only factor. See Parker v. Columbia Pictures Indus. 204 F. 3D 326. 336 2D Sir. 2000. Plaintiffs need not show that the swimming services they were denied were needed homeschooling exercise, as set forth above. Title 3 and 2 prohibits discrimination on the basis of disability in the full and equal enjoyment the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation. 42 U.S. C. Section 12182 A emphasis added. Title 2, which this rule addresses, applies to state and local government entities, and, in Subtitle A, protects qualified individuals with disabilities from discrimination on the basis of disability in services, programs, and activities provided by state and local government entities. Title 2 extends the prohibition on discrimination established by Section 504 of the Rehabilitation Act of 1973, as amended, 29 U.S. C. 794, to all activities of state and local governments regardless of whether these entities receive federal financial assistance. 42 U.S. C. 12,131b65. Title 3 further prohibits the following conduct: affording an individual, on the basis of a disability, with the opportunity to participate in or benefit from a good, service, facility, privilege, advantage, or accommodation that is not equal to that afforded to other individuals. 42 U.S. C. Section 12,182(1)(2) emphasis added, imposing eligibility criteria that screen out individuals with disabilities from fully and equally enjoying any goods, services, facilities, privileges, advantages, or accommodations, unless such criteria can be shown to be necessary for the provision of the goods and services being offered. Id. Section 12,182(2)(e) emphasis added, as a plain reading of the statute demonstrates. Title 3 of the ADA is concerned with providing individuals with disabilities with equal access to the goods and services being offered by places of public accommodation, and since the place of public accommodation is owned and operated by a local city government, it is also covered under Title 2. It does not require places of public accommodation to provide individuals with disabilities with a particular good or service. It requires places of public accommodation to provide individuals with disabilities with equal access to whatever goods and services they provide to non-disabled individuals. This is a case about whether the plaintiffs have been denied equal access to the swimming facilities available to all participants as compared to non-disabled individuals. The city employees further add egregions by imposing eligibility criteria by asking specifically the legally disabled to perform these tasks while no one else had to perform these same tasks in order to use these services. This screened out individuals with disabilities from fully and equally enjoying any services. Clearly and undeniably, the plaintiffs were all denied services upon being required to perform extra and their inability to do so by their own physical and mental disabilities. Nobody else was singled out and required to lift the buoy line, so their child would go under, not over the buoy line, as well as to go up the water, slide and down with their child between their legs to be afforded these services. Nobody but the plaintiffs. This is seen by the bruised picture of the plaintiff's 9-month pregnant belly timestamp and dated to that date/time, which only time will tell if the blow to the unborn baby's head has or will have any long-term neurological effects. Emphasis added, requiring the plaintiff to go in and out of the pool to lift the buoy line as well, when then the unnamed witness staff told her that she needed to go up the slide and back down with Isis, her large 9-year-old autistic child, in between her legs. As seen in this clip, https://youtube.com/shorts/f4q66hn feature equals share. Again, it is clear and undeniable the plaintiffs were denied reasonable modifications to the rules of the services when given the final ultimatum by Becca Seeley, when she not only acknowledges and admits she understands the plaintiffs are disabled, when she says "I get that," but also clearly doesn't care moments later when she tell them they need to leave or the police would be called to decide, as seen in the video evidence https://b/jr59xfisu. Let us make this quite clear, that rather or not the defendant's attorney Mr. Doyle is representing the defendants or his associates from his law firm, the egregions still remain the same, and counsel, despite some changes, doesn't change the facts of the case matter. I'd also like to make clear that these egregions were committed on the anniversary of the signing of the Americans with Disabilities Act and couldn't have been a worse time in the history of show law, as we are more than prepared to bring the egregions to a federal court, as this is a federal matter, as it deals with government employees and officials of show law. What is worse and even disturbingly egregious is the fact that at the time of the incident, Ms. Pustilock was at the end stage of her pregnancy, 9 months in fact, and delivered days after this egregion took place on August 5, 2021. In fact, Ms. Pustilock is also legally disabled, like the rest of her family. Your defendant states they have zero wrongdoing, yet they continue to hide key witnesses who were present and identified on video at the time of the incident. In fact, the witnesses are related to influential people in the show law area, and such you present no affidavits clearly if you are to do so would not only jeopardize your entire case, but would also be deemed perjury in light of true evidence, which was maliciously struck down by the Honorable Judge Hardy. Plaintiffs were denied the ability to enjoy the swimming facilities and were forcibly under duress kicked out. The pool has steps/ladder. Why was Isis Lothis not allowed to use the steps/ladder? Ms. Pustilock was coerced into entering the pool to lift a heavy buoy, property of the city of Show Low. Why in her obvious state was she not assisted instead? Or better yet, why was she demanded to go down the slide when clearly there is a sign stating the exact opposite? Younger, smaller children than ISIS were allowed to swim. Why was ISIS not allowed to use the pool? Sorry, but before I go forward, if I seem like I'm ranting, please forgive us as we have no ADA coordinator. I presented in my motion to compel the discovery of key witnesses in this case, but all was stricken down like all of my factual key evidence. We have videos and photographs of the direct evidence from that very day. It has recently been made clear to us due to the nature of this case and issues alongside the close connectivity in the Sholo area, we would not have a fair trial, as it has been proven to us that we cannot even secure photocopies of the court paperwork without the possibility of Ms. Becca Alsop Sealy and her defense from obtaining such sensitive information before even the courts do so. I've been able to receive free photocopies, even after hours of operations, and when closed on holidays, directly from the close friends of the defendant. Diana North https://edu B/A9A0 OIB, for who will be subpoenaed. This is why we will file this federally if we cannot come up with a reasonable monetary figure. We are fully aware of Becca Alsop's connections to former Arizona politicians, as well as the current Gov. Doug Ducey, whom during this civil rights case appointed her friend Joseph Clark. We are fully aware of the intentional malice of the Doyle firm and its associates, as well as the Navajo Superior Courts and the Honorable Judge Hardy. Mr. Doyle used statutes that do not apply to the disabled, but rather to prisoners/inmates, which was not struck down by the Honorable Judge Hardy. Last time I checked, prisoners and inmates do not have the same rights as the law-abiding disabled citizens do. So, which is it? We do not have any criminal records of the sorts and are both outstanding citizens, as well as reverends. Because of this issue, poor little Isis cannot go back to the aquatic center and use it like any other child in the area can. Because of this, she screams no, no, no whenever we go to Sholo for any reason. It's quite obvious we all have been affected. There is not a jury in the entire country, unless it was hung, that will see this ordeal in your way. We know we can file federally with this complaint, which will most certainly allow for a truly fair trial. If the monetary amount is not reasonable, we are prepared to begin counseling for the situation, as it has affected our dignity, our self-worth, and our self-esteem. Any affidavits presented we will tear apart with our key evidence. I cannot promise that the media will not pick up on this either, as there are several elements in this political web of corruption. Ms. Becca Alsop, in the government position she is in due to employment at the Sholo Aquatic Center, should be well aware of the implications of not providing reasonable accommodations upon request. Upon acknowledging she understood the plaintiffs are disabled, Becca knew of Isis's disability. This is evident in the video evidence when she acknowledges and states, "I get that." https://edu B/SQBNML5XPay. As evidenced by Becca's Facebook profile, https://www.facebook.com/Becca Sealy. 7. Ms. Alsop Sealy has several close connections at the Sholo Police Department. The odds that one of her friends would have arrived on scene to remove the plaintiffs was highly probable. This is why Ms. Sealy ultimately felt very comfortable with threatening to call police on the plaintiffs, stating, "Well, let the police decide. This is in no way criminal activity nor a criminal matter." It was nothing more than a request due to a disability, and very likely the police would have sided with their close friend Becca Alsop Sealy. This is why we are asking for $10 million. This was more than malicious, as a 9-month pregnant woman and an autistic child cannot be construed as anything less than a pregnant woman and an autistic child. Meaning, upon visual inspection of Cynthia, it was highly evident she was very pregnant, as well as upon simple communication with Isis, it is highly evident she is on the spectrum of autism. Furthermore, Becca reaffirms the other lifeguards and their requests by not correcting the actions of those employees that were below her. There was no apologies or empathy from Becca for the actions of her lifeguards or herself over the discrimination on the plaintiffs. She acted in malice and threw the plaintiffs out, who quickly left under duress in fear of the threat of the police being called, which by itself shows the Lothis/Ms. Pustelok are very compliant, regardless of obvious disability discrimination, to arrest them in fear of police brutality. There is much evidence to prove this again and again, and it was struck down by the Honorable Judge Hardy. This was a simple accommodation request that should have and could have been granted with ease. Instead, the plaintiffs were treated like second-class citizens, and ultimately told by management, Ed Mooney and Jay Brimhall, to call first if This was a simple accommodation request that should have and could have been granted with ease. Instead, the plaintiffs were treated like second-class citizens and ultimately told by management, Ed Mooney and Jay Brimhall, to call first if we considered coming back to the pool. https://u2b/u9-8fzg, thus isolating the disabled plaintiffs further from community programs and functions, which all is against federal laws. Furthermore, the city of Sholo has no ADA coordinator nor has ever followed up with us in writing as their policies state, thus violating federal law again. Let's not let Arizona be known as a rogue state. If this gets filed federally, criminal penalties for Becca will in fact be pursued to the fullest extent of the law. This could be but not limited to jail time and fines, to say the least. We really hope you all can learn from this lesson. The governor's appointment of Becca Alsop Seeley's friend Joseph Clark will not go unnoticed. The entire state of Arizona could be affected. Also, let's not forget Navajo Superior Court intentionally scheduled bus reverends on a Sunday, which was done in malice since this was intended to interfere or interrupt our day of worship. Municipalities cannot make use of the qualified immunity defense. They can be held liable even if they did not know they were violating the victim's constitutional rights. I would like to bring light to Section 1983. Blocking lawsuits in state court is illegal and unconstitutional. A judge who breaks the Constitution of the United States of America is disqualified for qualified immunity and is declaring war against the federal government, which is treason. Only a judge or official can be disqualified for immunity upon dismissal of a plaintiff's civil rights. In this situation, we have noticed that Melinda Hardy will not address the Federal Americans with Disabilities Act and the Rehabilitation Act and is suppressing our undisputable fact-based evidence of civil rights violation that is afforded to us by the U.S. Constitution. She would be considered a trespasser of justice, which means that any judge's orders are void and have terminated their own subject matter jurisdiction. Melinda Hardy consolidated our 3 ADA cases into one and still persists that we pay for the court fees on 2 consolidated cases, and has not addressed all but Cynthia Pustelak's negligence claims, completely ignoring the ADA, the Rehabilitation Act, and furthermore federal law. Ms. Pustelak's claims are a second instance, and separate from Joseph Lothis in regards to the breaking of the Americans with Disabilities Act and negligence. Joseph's tort is only an ADA claim of reasonable accommodations to the rules, policies, practices and procedures, just the ADA, which means holding Rule 26 or any rule over the understanding of the disabled plaintiffs is in fact breaking the Americans with Disabilities Act, Title II as well. You do not have the authority to diminish our God-given civil rights. Furthermore, Judge Melinda Hardy, upon the meeting on March 25, 2022 with plaintiffs and defense attorneys repeatedly, even after being corrected, insisted on using Nazi derogatory slur Polak, or rather, Ms. Polak, https://youtube.com/short/ocdcxfw1bfs, feature equals share in place of Ms. Pustelak. Polak is anti-Polish sentiment term for negative attitudes, prejudices, and actions against Poles as an ethnic group, Poland as their country, and their culture. These include ethnic prejudice against Poles and persons of Polish descent, other forms of discrimination, and mistreatment of Poles and the Polish diaspora. 3. German notice in German-occupied Poland, 1939. No entry for Poles. This prejudice led to mass killings and genocide, or it was used to justify atrocities both before and during World War II, most notably by the German Nazis and Ukrainian nationalists. Nazi Germany's Directive No. 1306 stated, Polishness equals subhumanity. Poles, Jews and Gypsies are on the same inferior level. 5. Nazi Germany killed between 1.8 to 2.7 million ethnic Poles. 140,000 Poles were deported to Auschwitz, where at least half of them perished, thus criminally creating a hate crime felony in the Navajo Superior Court. Breaking Arizona Revised Statutes Title 13, Criminal Code Section 13 to 701 and Federal Code 18 U.S. Code Section 249 Hate Crime Act. Since at the time of the commission of the offense, the defendant was a public servant and the offense involved conduct directly related to the defendant's office as well, the victim, Ms. Pustelak, of the offense is a person with a disability as defined in Section 38 to 492, subsection B. The emotional and slanderous damages are a form of bodily harm/personal injury. This fulfills the elements for a criminal charge. Since when is it okay for judges to use racial slurs? We would like to note that a judge who forfeits absolute judicial immunity by committing crimes and deprivations of civil rights like the Americans with Disabilities Act in conspiracy with others, including other judges, defense attorneys and other state officials, can be sued in his or her individual capacity in violation of civil rights cases under 42 USC 1983, 1985, and 1986 and will be. One should consider a judge bad only if they show a pattern of behaving or ruling in a manner that is preventing or hindering you from receiving full, fair, impartial hearings or the full, fair, impartial administration of justice, or you have seen evidence which would lead a reasonable person to believe they could be prevented or hindered from receiving full, fair, impartial hearings or the full, fair, impartial administration of justice. This is especially pertaining to the case concerning Judge Melinda Hardy. The criteria used in deciding if a judge is bad is not how they handle a high-profile case or people of influence, but how they handle the poor, prosecutorial misconduct and the unrepresented. Regardless of how bad a judge is, they will undoubtedly make some correct decisions. We consider a judge bad if they do not faithfully and consistently adhere to their oath of office and aggressively pursue justice for all. Anything less is unacceptable and is the definition of a bad judge. We have clear and obvious photographic and video evidence of the individual witnesses whom the defense counsel is hiding and refers to as teenagers, are in fact related to City of Show Low council members, and some of these council members are employed at the Navajo Superior Court. This is why their names have not been provided to the plaintiffs, thus obstructing justice. We demand justice, and if this is not addressed, it is tampering with evidence and obstruction of justice. 18 U.S.C. Section 1503, an act that corruptly or by threats or force, or by any threatening letter or communication, influences, obstructs, or impedes, or endeavors to influence, obstruct, or impede the due administration of justice, by not only the defendants but as well as by the judicial officers of Navajo County Superior Court, and is breaking 42 USC 1983, 1985, and 1986. Charges will be pursued in the Supreme Court of the United States if needed. When a judge in the United States of America takes their oath, it states I, do solemnly swear or affirm that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as under the Constitution and laws of the United States. Treason is a unique offense in our constitutional order. It is the only crime expressly defined by the Constitution, and applying only to Americans who have betrayed the allegiance they are presumed to owe the United States. This allegiance is the oath that is sworn to our great nation and its Constitution. The punishment for treason of the United States of America and its Constitution states, whoever, owing allegiance to the United States, levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be imprisoned not less than 5 years and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States. The assembling of a body of men/women for the purpose of effecting by force a treasonable object, and all who perform any part however minute, or however remote from the scene of action, and who are leagued in the general conspiracy, are considered as engaged in levying war, within the meaning of the Constitution. We believe we are due a recuse and under 28 U.S.C. Section 455, and ask for a motion to change venues due to the nature of the relationships, the completely clear and obviously undeniable evidence that is being ignored, as well as a very obvious conflict of interest, here at Navajo Superior Court. Judges simply have an ethical obligation to recuse themselves if they know of any reason to do so. We respectfully request a recusal and change of venue due to the same respects. A fair trial for such a clear-cut matter should never be provided in the first place. Given the relationships and influence of Becca Alsop Seeley,